All right. Let's go ahead and get started. My name is Shelly Klein. I'm the Special Events Director for the Freelance Exchange of Kansas City. Thank you so much for registering and signing up for this, our first virtual focus seminar. So I'm excited to see how everything goes. This is the first for us. So I appreciate you guys participating. I want to thank Chris Brown, who's going to speak to us today. Chris he represents startups and freelancers and small businesses through his law firm, Venture Legal. He co-founded Contract Canvas, a digital contract platform for creative professionals. And he did just share his information in the chat, his website. I'm going to go ahead and I'm going to turn it over to you, Chris, and get started. And if everyone could mute yourselves, that would be great. And we'll turn it over and let Chris take over.
Great, thank you so much. Good morning, everybody. This is kind of early in the morning, I think, for a lot of people to be dealing with legal issues. I love these issues. This stuff to me is super fun. I get made fun of by pretty much everybody by how much I love contracts. I think that they're super important to what you do as a freelancer, regardless if you're a copywriter, web developer, logo designer, whatever it might be. Contracts form the Bible, if you will, between you and your client and you and your subcontractor and anyone else that you might be working with. So while there's an awful lot more to your client relationship than your contract, of course, the contract is really the place to start. Anyway, I've shared in the chat box there a link to these slides. If anybody wants to go there, it's just a Google slide link, so you can download the slides or go through them on your own later if you want to. It's just my website, venturelegalkc.com/FX of KC. So a little bit about myself. So I started out my career as actually a recording engineer. I was up in New York City doing work in the music business. And about 6 months after I graduated undergrad, I made the decision to go to law school, which brought me back here to Kansas City, where I studied at UMKC Law, worked at a small firm here in town for a few years, and then branched out on my own in 2013 when I created Venture Legal and also a marketing company. So I ran a law firm marketing business for about 3 or 4 years before I sold that in 2018. But this entire time I've been running Venture Legal as well. And I focus heavily on working with startups, so tech companies making apps, websites, and so on, as well as a lot of work with freelancers like yourself. I do a lot of work with the Freelance Exchange. I present at KC Art Institute and various other places. And then more recently, in the last couple of years, I've been working on a platform called Contract Canvas, which I'll come back to in a little bit, but it's a digital platform for freelancers to create their own contracts on the internet. I've already mentioned the slides, so you can go there, and that's in the chat box there as well. Here's my legal disclaimer. Lots of lawyers like to put up a big paragraph of stuff. I like to keep mine pretty simple and just say, don't do anything stupid. So this is general advice. This is not a one-on-one conversation, and so it's not confidential either. And just by the nature of us talking here, I'm not your lawyer. I just do this to cover myself. So actually, before I even get in here, I want to ask, what does everybody do? If everybody can open up their chat box, maybe you can just kind of briefly tell me what you do, just graphic designer, web developer, or whatever it might be. That'd be really helpful for me to know as we're going through this, what kind of topics I might hit on. And then as we're going through, feel free to interrupt with questions. I think you're muted, I'm not really sure, but if you're muted, feel free to put questions in that chat box, and I'll respond in real time rather than waiting until the end of the presentation. I've only done 3 of these Zoom presentations. I normally present in person, and I love having conversations with the audience. So it'll be interesting to see, if we can get more of a dialogue going here, which is what I'm trying to do today versus what I did the last 2 times, which was me just talking for 45 minutes, which I think was probably boring to listen to, but hopefully it's helpful. So we've got marketing consultants, web developer, copywriter, someone new to freelance. That's good to know. Very good. Yeah, these are all the typical things you see in Freelance Exchange, which is great. Okay, very good. So what is a contract, right? So at the heart of things, you only need 3 things to create a contract. The first thing you need is an offer. Second thing is an acceptance. And then the third thing is some kind of thing of value, what lawyers call consideration. So this could be as simple as I say, I see Angela's on here. So I say, Angela, hey, I'll build you a website if you pay me $5,000. And Angela might say, okay, fine, that's a deal. So that was my offer to build the website. And she accepted it by saying, okay, great, let's go. The consideration component there, my consideration is the actual work of developing the website. Her consideration is paying me $5,000. That's it. That's all you need to create a contract. So at that moment, if I don't build the site, she could sue me for breach of contract. If she doesn't pay me, I could sue her, and so on. You don't actually have to have a written agreement. And so that's something that a lot of people don't realize. With that said, written agreements are really a good idea in most situations. If I hire you to do a 20-minute project and I pay you $50 or something, you may not need to do a written agreement. But, if you're doing a $5,000 web development deal, it's probably worth it to put something in writing. And so I usually recommend that you use some kind of a written document with people that you're working with. There are a few exceptions to this general rule that says that oral agreements are enforceable. Those exceptions are things like prenuptial agreements, real estate deeds, wills and estates and trusts and things like that. Documents like that are hard to prove if they're real in a future date usually have to be in writing. But for the most part, what all of you are doing in terms of your work with your clients, content writing and so on, you could do it orally. So the next question is, where do you actually get a contract template? And these are the 4 ways that I kind of see people doing it the most. The first example is write it on your own. And this is actually a pretty good way to do it. There's a lot of downfalls to doing it this way, but there's a lot of reasons why you might want to write it yourself. And the key number 1 reason is then you know exactly what it says. And if you have a unique business model, you can make your contract custom and perfect for you to match the exact way you operate. The downsides, of course, to writing it your own is that you're not a lawyer. Well, I'm assuming none of you are lawyers. And so you might miss things, right? And that's not to say you will miss things. It's just when I see a contract that's written by somebody who's not trained in contract law, there's usually things missing or things written incorrectly. But again, if you're doing small projects, if you just do a lot of $1,000 deals, writing your own is really not that risky, because the risk to you and the deal falling apart is not the end of the world. Whereas if you're going to sign up a client and do 10 hours a week for a year, writing your own, I think, presents greater risk, because, what if you screw up the termination rights and your client cancels on you 2 months in and you don't have any kind of recourse? Okay, so then you can buy a template online. There's lots of places you can go on the internet to do this. There's lots of places you can download free templates. There is, in fact, on my website, Contract Canvas, we provide a free, simple client agreement that you can just type in your email and download. And it's really great for small projects, but I wouldn't necessarily use it for larger ones. The next option is use a platform. So this is kind of some self-promotion here, but Contract Canvas is a platform like I'm talking about. Other platforms would be things like Bonsai or Ann Company, Rocket Lawyer, LegalZoom, some of those places. They're not necessarily platforms, but they provide a system for you to create a contract and sometimes get it signed with your client. And then there's other systems that integrate accounting systems and contracts kind of all in one, or maybe like a proposal website where you can have your client sign through there. Anyway, there's this option of using what we were calling a platform now. And so the last option is hire a lawyer. And depending on what you're doing, this may or may not be a good decision. I'm a lawyer, so I'm biased, but I think you should try to work with a lawyer if you can, especially on larger projects. But I acknowledge that lawyers can slow things down. They can make things more complicated. Depending on the lawyer that you work with, they might take a deal that you think is a simple 2-page deal, and they might give you a 10-page contract that scares your client. So, I get those concerns. With that said, if you hire the right kind of lawyer and you work with your lawyer the right way and communicate exactly what it is you're looking for, and also what you're not looking for, you can usually get a pretty good deal. The other concern with going to a lawyer is they're expensive. I think the average billable rate in America is about $250 an hour. So, it's not cheap. But again, if you're doing $1,000 project, you can probably skip the lawyer. If you're doing a 1-year deal where somebody's going to pay you a couple $1,000s a month, it's probably worth $1,000 to get a lawyer to help you structure that, to make sure that you're not getting into a bad relationship. Anyway, those are 4 options of how you get a template. Here's the 2 most common formats that I see. You could do single project agreements. So somebody might come to you and say, hey, I want a logo. Okay, that's easy enough. That's probably a single project agreement. You sign a contract that says you're going to make a logo. They're going to pay you $1,000, and you do the project, and then you put the contract away and probably never look at it again. But you might try to get more work out of your clients. And so that's where the master service agreement and statement of work comes into play. And I love this format because, one, I think it's easier for you to manage your contracts with your clients on an ongoing basis when you use the MSA. and SOW format. But two, it helps you to upsell and get more work from your clients, because if you can get them into a master service agreement that runs, 1 year to 5 years, it's easier for you to go back to that client and get more work. It's easier for them to call you up and hire you to do more work. So going back to the logo designer, maybe that person's a graphic designer, they do more than just logos. So maybe they sign a master agreement that says, hey, we're going to work together. Here's the legal terms of our relationship. But it doesn't actually require the contractor to do anything, and it doesn't require the client to pay anything. All it says is, here's the terms that we're going to work under. So then you do statement of work number 1. And statement of work number 1 might be a marketing strategy. Statement of work number 2 might be a logo design. Statement of work number 3 might be a website development contract. And then statement of work number 4 could be a maintenance agreement for you to maintain that website on an ongoing basis. And you do those in order. And the beauty of doing that is your statement of work could just be like, 1 page or 2 pages. Meanwhile, you have maybe a 5-page master agreement that sits in the background that governs the entire relationship. The other thing is, if you're working with larger clients, like Fortune 500 companies or whatever, they're going to be more difficult in negotiating the MSA, because they're going to want to look at every single line. But the beauty is, once you get that MSA signed, a lot of times you can get people at that big company to sign SOWs in the future without going through their legal department. Now, that might be against the company's rules or whatever, but hey, if they sign it and they pay you, that's probably good for you. So anyway, using statements of work, it's just an easier way to get projects signed, approved, and get paid for. I see a couple of questions. Is the slide going to be available later? Yeah, so if you look up at the very top of the chat, and I'll copy and paste it in case the full chat isn't available if you came in late. Here's a link to my website, venturelegalkc.com/FX of KC. That'll take you straight to the Google Slides where you can download them. Okay, and then can it be part of MSA to add an SOW by email? Yeah, that's a very good question. In fact, a lot of my clients ask me that. I generally don't like doing that, because you send emails back and forth all the time and you could totally screw up. However, a lot of my clients tell me that's just the way they work, and that they're not going to change that. That, the way that their clients and them have a relationship is they go back and forth in an email and say, hey, let's do this. So to accommodate that, what I do is I provide them with a couple sentences that they can put in the email. And so what I would recommend is, if you're like going back and forth to your client about, I'll do a logo and I'll do 3 rounds with 2 rounds of edits, and it's $5,000. And the client's like, oh, I don't want to pay that. I'll pay $2,500. So you're going back and forth. A good thing to do is, once you reach that final agreement, just open up a new window or a new email, forward it or send it to your client with that sentence that I provide. The sentence would say something like, this email creates a statement of work under our master service agreement dated May 4th, 2020, or whatever. And that way it's very clear that that specific email is an SOW, and that it's, more importantly, that it's tied back to the master agreement. And then make sure your client responds and says, yep, sounds good, or thumbs up, or whatever. It's not the best way to do it, legally speaking, but it's certainly something you can do. And I have clients that are absolutely doing it. So, okay, those are the 2 contract formats. I have a really long blog post about MSAs and SOWs if you want to check it out. Actually, I think if you just Google MSA SOW, I think it's the first thing that pops up. And if you want to learn more about that, you can hop over to that blog post. Okay, so we're going to go through, I don't know, 6 or 7 different terms here that are what I think are the most important terms. I should also probably reference, I called this presentation something like practical thoughts on client agreements, but I decided at the last minute to change it and make it more about both client agreements and subcontractor agreements. So as we go through these various sections, I'm going to talk about it on both sides. And the difference being, when you sign a client agreement, it's obvious, it's between you and your client. When you sign a contractor agreement, or you might call it a subcontractor agreement, it's between you and the person that you're hiring to do work for you. So that might be a subcontractor in the sense of, if you're a web developer, you might hire out a copywriter to help you with the web content. And so that copywriter would be a subcontractor to you, because you're doing that for your client. Whereas if you hire that same copywriter to work on your own personal website, that's not really a subcontractor, it's just a contractor or an independent contractor. And these words don't matter too much. At the end of the day, the concept is the same. If you hire somebody to do work for you, whether it's for you or your client, you need to have some kind of a contract with them. Anyway, so I'm going to cover both sides of that, the client side and the contractor side. And I'm going to go through all these various terms here. So the first term that is critical in your contract that I see people screwing up all the time, even just last week, and I was reviewing a freelance contract, is how do you identify the parties? And there's two places primarily where you do this in the contract. The first place is at the very top of the contract, which is called the preamble. And it usually starts out with something like, this marketing agreement is between Chris Brown or, Contract Canvas and logo designer XYZ or whatever. And then the second place you do it is in the signature box or the block at the bottom of the contract. And that's where you're actually signing the contract. Those are the two places where it is the most important to capture the correct legal name of the parties. Throughout the middle of the contract, you can do it kind of however you want, as long as you define the parties. And so usually at the top of the contract, when it says, this is a contract between, Chris Brown and whoever, you would usually put in parentheses after the name and then give like an abbreviated name. So like my law firm legal name is Venture Legal LLC. But I'm not going to write my name Venture Legal LLC throughout the whole document because that would make it really hard to read. So I would just rephrase it to Venture Legal. Or sometimes you'll see it rephrased to client or company or whatever. And then for the other party, you do the same thing. So you could call yourself client and contractor throughout the agreement. But I prefer to use real names whenever possible. So I see someone's name is Patty on here. So, if Patty Robb was operating a business under her own name, it might say, this is a contract between Patty Robb, and then in parentheses say Patty or Rob, and Venture Legal client. And so your entire agreement refers to you using your name and then client. And that way, when you're reading through the contract, it's a little bit easier to remember who's who. What you don't want to do is if you're like assigning, or let's say that you're, assignments are a good one. So you do an assignment agreement to assign copyright to somebody. Don't use assignor and assignee because nobody talks like that in real life. And when you're reading those sentences in the contract, it's going to be confusing. So, assignor hereby assigns to assignee the following rights. You're going to mess up the names at some point and get them backwards. Okay, anyway, I'm going on a tangent here. So the preamble at the top and the signature block is where they go. The signature block is extremely important. I'd recommend you screenshot this page or download these slides. If you screw this up, you actually might end up signing a contract under your own name as opposed to your business name, which is not what you want. So let's just assume that you operate under an LLC. So I'm going to use Patty again. Let's say that Patty Robb has an LLC and it's called Robb Enterprises LLC. Or actually, I should probably just use my example because my name's on the slide. Chris Brown and then Brown Enterprises LLC. If I'm signing the contract as an individual, so let's say that I hire one of you to paint a painting for my house. I'd probably do that under my own individual name. In that case, you would just sign your name and print your name. And at the bottom of or at the top of the contract, my name would just be Chris Brown. But let's say that I was asking you to paint that for my office. And let's say that I had a business entity called Brown Enterprises LLC. At the top of the contract, it'll say Brown Enterprises LLC. And then at the bottom where I sign, it would say print your company name. So Brown Enterprises LLC, sign your name, print your name, and then print your title. So in that case, my title might be managing member, or it could be founder or CEO or whatever. There are technical titles you probably should use, but the most important thing to do is just try to be consistent. So if you use founder, just use founder all the time. Or if you use CEO, always use CEO. Don't flip back and forth between CEO and president or whatever. Anyway, what makes this a binding contract between you and my LLC is the fact that I signed the contract for the LLC. Let's say that, again, that we were doing this for my office, but I left off my business name and I just signed it under my own name just because I wasn't paying attention. All of a sudden, that's a contract between me, a human being, and you. And that may not be great because if I don't pay you, you could sue me, Chris Brown. You could come after my house or my car or whatever else. Whereas if it was a contract between my business and you could only sue my business. You could sue me individually if I personally did something wrong. But for example, if I just didn't pay you, that's not Chris Brown's fault, that's Brown Enterprises' fault. And so you could flip this around. If you have an LLC for your freelance business, it's a good idea to make sure that you're signing your contracts under your LLC name so you're not personally liable for anything that happens. A good example for a freelancer is maybe you commit copyright infringement, or one of your subcontractors commits copyright infringement and your client sues you. It's really nice to have your LLC there as a shield to that liability. It's not a perfect shield. You'll still be liable for anything that you individually do, but if you have employees or contractors or anybody working for you, it's really good to have that in place. Okay, so the next topic is service terms. Obviously, you want to have a good paragraph or two about what it is that you're doing, or sometimes multiple pages. If you want to say, Gene will build a website for Bob, that's really just not good enough. How many pages? How many words per page? There's so many things left out of that. So the things that you want to consider when you're writing up your services or your scope of work, first of all, be as clear as possible. So back to that example, you're going to want to say things like, I'm going to build you a website that's going to have 12 pages. Each page will have, 200 to 500 words. I will write those words, or client will write those words. And then you might want to say things like, each page will feature at least one stock photography item. And then you got to talk about where those photos come from and so on. You also want to include timeframes if they're relevant. Sometimes a freelancer might want to sign kind of an open-ended contract that gives them however long they need to build a website. But more so, I think it's appropriate to have timeframes that protect both you and your client. And then if you're hiring a subcontractor, you definitely want timeframes in there, especially if your client agreement has a time frame. So if your client says you're going to build me a website in 3 weeks, you need to make sure that your subcontractor agreement says something like 2 weeks, so that you have a little buffer room between when the contractor has to be done and you have to deliver it to your client. And then also think about what's excluded. So in the context of a website design project, you might exclude hosting, or you might exclude ongoing maintenance, or stock photography may not be expressly included. If you're doing copywriting, are edits included in the contract? If they're paying you a fixed fee, does it come with 1 or 2 rounds of edits, or is it just 1 round? Anyway, so make it very clear what is included as well as what is excluded from the contract. Okay, payment terms are kind of the same idea. So, you don't want to just say Bob will pay Gene $2,000, because still it just leaves out an awful lot of detail. So think about, is it payable in one lump sum, or is it payable up front? Is it non-refundable? Is it going to be based on milestones or whatever? So here's some things that you might want to think through. First of all, is process. So how do you actually get paid? How do you invoice? Are you going to invoice and then the invoice is due 30 days later or 15 days later? Will they pay you online with a credit card? Will they have to mail you a check? Whatever it is, you're going to want to make it very clear what all of those various payment mechanisms are in your payment section, as well as timing. So especially if you have subcontractors, you should be thinking about timing. If your contract says that your client will pay you $5,000 at the end of the project, and then you go out there and hire a subcontractor, and that subcontractor is going to get paid at the end of their portion. Well, maybe it's a copywriter and they finish it in month 1, but you don't get paid until month 6, in your client agreement. Then you have to pay your client, then you have to pay your contractor before you get paid from your client. And that can put you in a bad spot. So you always want to think through timing and try to get as much money from your client up front as possible. And meanwhile, kind of try to delay payments to your subcontractors as much as possible. That doesn't mean you should be unfair to them, but you just need to think through all of that. And then also think about what's refundable. So if you're doing a $5,000 website, again, maybe you charge a $2,500 non-refundable deposit. So if the client cancels halfway through the deal, at least you get to keep the $2,500. If you're doing a month, an annual retainer contract, you should be thinking about, well, if they pay you $1,000 every single month and they cancel in month 6, what about the last 6 months? Do you get paid for those or not? And so a lot of times you'll see a provision that says, if they cancel, 6 months before the end of the term, that you'll get to keep some additional money, or maybe they owe you more money. And if they cancel the first month, they might owe you more money because there's more time on the contract left. Anyway, point is, figure out what's refundable and what's not if the contract gets terminated early. And then the last thing on payment is think about reimbursable expenses, which I've hit on a couple times already. Things like buying stock photos, maybe buy a font or a website theme. If you want to get reimbursed for those expenses, then you need to think through putting that in your contract. If it's not in your contract, there's a very good chance your client is not legally obligated to pay you for that. So the best way to handle this is either to list in the contract exactly what it is you need to be paid back for, So if you are building a website, you might say, this theme costs $80 and then just put it in the contract. But often you don't know what expenses you're going to pay when you sign the contract. And for that reason, I usually say you just provide a sentence that says the client will reimburse you for your reasonable expenses, but only to the extent that they're pre-approved by the client. And that second half is the part that the client usually cares about, because they don't want to sign something saying they will reimburse you for everything. They're going to want to have some control over what you're going out there to spend money on. Okay, intellectual property is great. Actually, any questions on services or payment before we move forward?
Real quickly, can you speak to like termination clauses, like 60 days, 90 days that can protect you? It's kind of a variation on the theme of, someone quits, but how do you allow for that? Or how do
Yeah,
you
actually, if you
include
don't mind, I'm going to come back to that in about 3 or 4 slides. I have a whole slide dealing with termination.
that?
That's a
Perfect.
very good point.
Thank you.
Yeah, sure thing. So let's jump
Just
into
a
intellectual property.
question.
Oh, yeah, I don't know who that is, but sure.
John here. So with the
Done.
second half of that reasonable expenses question,
Mhm.
can those approved expenses, can those just take place across email? Asking the client, hey,
Oh, good
5-year
question.
for
Yes.
logo.
I like to include in my contract templates that that most things can be done by email. I know earlier I said don't do SOWs by email, but I mean like basic communications, notice provisions. So it's up to you, and it's up to what your contract says. A lot of times it will say that the client will reimburse for reasonable expenses that the client approved in advance or whatever. But it also usually says in advance in writing. And so when it does that, unless the contract is clear somewhere else that writing includes email, I literally just put in parentheses right there, including email, to make it very clear that the expense reimbursements can be approved via email. And that's a very good question. Okay, so there's 4 types of intellectual property. This is a huge deal for most freelancers. First, we have copyrights, which create primarily creative works. So the creative is a very broad term. It includes, music and dance and art. It also includes computer code, so HTML, CSS, and all of that. It's a very broad area of intellectual property. Next most important for you probably is trademark law, which protects branding elements, names, logos, and so on. Next up would be trade secrets, which will protect confidential information. And then finally is patents. And patents are probably the least relevant for most of you. They protect mainly inventions. I'm not going to go in deep detail on what all these are. There is an ebook on my website, venturelegalkc.com, that talks about all of these areas in depth. It's like a 30-page ebook. So if you want to learn more about that, I'd say hop over there and click on the button that says free resources. But I wanted to give you a quick intro to this because this is important for the next section that we're going to talk through. In terms of copyright ownership, which is really probably 90% of what matters to you, there's really 3 ways that I see this handled on a regular basis. And this is for the client agreement side. So this is the agreement between you and your client. The first one is that you, the freelancer, will continue to own all of the intellectual property. That's great for you, right? You own it, you can relicense it, you can sell it, you can put it up on the portfolio websites, and you do whatever you want. The second option, which is by far more common, is to assign the intellectual property to your client. And this can take a lot of different shapes and forms, but the basic concept is the client owns everything that they pay you to build. If you do that, you just have to be really careful that you don't transfer things to them that you might want to reuse with multiple clients. And so as a real world example of that, my old marketing company I owned, we made law firm websites. And our contracts with our clients, who are all lawyers, which was funny, always said that we own the core assets, the website themes and the basic concepts of the designs that we build. However, the unique works that we create specifically for the client, we transfer to the client. So, we would make a website theme, for example, and we would reuse that website theme with multiple law firms. But to the extent we wrote a bio or an about us section or a services page, that specific contract or content, we never claimed ownership of. I didn't care if they took it and ran away and fired me and reused it somewhere else. I mean, I don't want them to fire me, but I tried to make it as easy as possible to work with us. So that's how we did it. We said the core assets we own, but the specific works we create for you, you own. And that's really a good, happy middle ground. But it depends on your client. If you're signing a contract with, Cerner or Sprint or T-Mobile, I guess they are now, or anyway, a big company, their contract will almost certainly say everything you make is owned by them. And if you try to make any exceptions to that, it's going to get difficult. The best thing you can do with them is literally create a list in the contract of exceptions to that rule. So if you are using a theme, like a WordPress theme with them for some reason, you would literally list, this WordPress theme will continue to be owned by me. But it's difficult because you don't always know up front all the various things that you might be using for a client. So it's as a practical matter, hard to do that. But most of you are probably working with smaller clients, mom and pop stores, small businesses, medium businesses. And in those cases, you can usually negotiate terms that allow you to keep ownership of the core assets of things that you might reuse with multiple clients. But then you flip this around and look at the the contractor agreement side. In that case, especially if you're using a subcontractor for purposes of one of your clients, you're going to want to make sure that you get ownership of almost everything. And if you don't get ownership of everything, you at least need to get some kind of a license that you can grant to your client to use it. So, the web development one is easy. I just keep coming back to that. Let's say you're building a website for a client and you hire, Julie for your copywriting. Well, you're going to want to make sure you get ownership of whatever Julie writes in that context to give to your client, because if you don't get the rights from your subcontractor, you don't have any legal right to give it to your client. And if your client expects to own it, that's a great way for a dispute to arise between you and your client. If for some reason Julie said, no, I'm not going to give you ownership of that content, then like I said a second ago, you at least need to get some kind of a license that you can then sub-license to your client to allow them to use that content. All right, so confidentiality, this gets back to one of those other areas of intellectual property I talked about, which is trade secrets. Depending on the kind of work you do, confidential information may or may not really be an issue for you. If you're working again with somebody like Cerner, they're going to have a pretty thorough non-disclosure agreement that probably sits outside of the client agreement. If you're working with like a bike shop down the street to make a new website or do some digital ads for them or something, confidentiality for them may not be as important. Either way, I like to include a confidentiality paragraph in my client agreement and definitely in my contractor agreements for when I'm hiring people to do work for me. Just to protect one or both sides of the deal with respect to their confidential information. If you're doing a marketing strategy for somebody, you're probably going to learn an awful lot about their business model. And, if it is a local bicycle shop, they may not want you going out there and telling your other clients, oh, well, bicycle shop down the street, they've got sales that look like this, and this is their target client or whatever. So you're going to want to protect that with some kind of a confidentiality provision. Here's 4 things that you should think about when you're doing that. So first is whether or not it needs to be unilateral or mutual. What I mean by that is a unilateral non-disclosure obligation protects just one party. So if I sign that contract with a client of mine to build their website for a bike shop, the bike shop may not need to protect my information, the contractor, the web developer. It might just be that I need to protect their information, but they don't need to protect mine. In that case, it would be a unilateral non-disclosure obligation. Mutual is the opposite. It's kind of self-explanatory. In that case, both parties are agreeing to protect the other party's confidential information. My default usually is to go to mutual because it's fair to both sides, but sometimes the other party won't agree to it or whatever. And in that case, you can do unilateral. Next up is, what do you actually deem confidential? You can do this a few ways. You can literally create a list and say business plans and marketing lists and so on. But what I prefer to do usually is just to say that any information that's not public that a reasonable person would deem confidential is confidential. And by that nature, it must be protected. What you really need to think about, though, is on the contractor side. So if you hire a subcontractor to help you on your client's project, you need to make sure your contractor agreement also says that any of your client's confidential information is also deemed confidential. The last thing you need is a subcontractor to run off with your client's information, because that's inevitably going to get you in trouble. You also might want to include exceptions. This would be exceptions to what is actually confidential, and as well as exceptions to the duty not to disclose it. So an exception to what is confidential might look like, information that becomes public through no fault of your own. So if you're representing KFC and you have access to their KFC's 11 herbs and spices, if that just gets out on its own and it's not your fault, well, you shouldn't be bound to protect it any longer. An exception to the duty not to disclose would look like, for example, if a court or the government come to you and say, we demand that you turn over all of the information you know about Cerner, then you'd have to give it to the government. So you'd want some kind of an exception for that. Of course, Cerner and big companies in general are smart enough to know that they should have they should have additional rights in there in those situations, and so they usually have more than just one sentence about that. And then the last thing is consider the length of the obligations. I see these going anywhere from 1 year to 10 years to perpetual. I don't like perpetual, just generally speaking. I usually say, go for like 5 years or 10 years, but make it 5 or 10 years after your contract expires. So if you're doing a 2-year MSA with somebody, it's during that 2-year window plus an additional 5 years. The next topic is somewhat related. It's called non-solicitation. And there's 2 different ways to look at non-solicitation, and it depends on who you're working with. So when you're working with a client, if you have subcontractors, it's usually a good idea to prohibit your client from going around you and hiring your subcontractors without going through you. This is somewhat bad for the local economy, but it's not as bad as a straight up non-compete, which I'm not going to talk too much about, but it literally just says your clients will not hire your subcontractors without going through you. On the flip side of this, when you have a contractor agreement, you're going to want to have something in there that says that your subcontractors will not go to your clients without going through you. Because you might be working with 3 different contractors on a client project, and it would not be fun if one of those subcontractors went around your back, took the client, left you out of it, and those other 3 people kept working with the client. Now, if the circumstances arise where it just makes sense for you to leave the deal and everybody else to keep working together, you can always provide permission to do that. But it's usually a good provision to include in your contract to protect your business in the future. Okay, here's Byron, back to your point, term and termination. This is a really big topic that you definitely need to have covered in your agreement. It doesn't necessarily have to be long, but it needs to be talked about. The first thing to think of is, do you need an actual term of your agreement? So if your agreement is to make somebody a marketing strategy, the term could be something like 1 month or 3 months or 1 year or whatever it might be, but you also may not necessarily need to define a specific term. You might have milestone like progress deliverables along the way, but you may not necessarily need to say this is a 1-year contract. But other times you do need to have a term. So let's go back to the example of doing maybe marketing strategy for somebody on a monthly retainer. Maybe they pay you $1,000 a month for 12 months. That second part of what I just said there, the 12 months, that's the term. If you don't have some kind of a term in there, then it's kind of unknown as to when that relationship will end. If it's a perpetual term, it starts to make you look like an employee, which the IRS could come in and reclassify you as an employee. And that's not so much a risk for you, but it would be a risk for your client. So if you're doing some kind of a retainer relationship, I would set some term, 3 months, 6 months, 1 year, whatever. The other cool thing about having a term like that is it gives you a natural opportunity to raise your rates. So if you don't have an annual contract with your client, if it's just a perpetual one, it can be awkward sometimes to go back to your client and say, hey, I want more money. But if your contract is coming up for a renewal, it's a lot easier to say, hey, Bob, our contract renews next month and my rate's going to go up 5%. It's a more natural time to do that. In terms of termination, there's 3 things that I think you should think through. So this gets directly to Byron's question from earlier. First is voluntary by you. Can you terminate the contract anytime for any reason, right? So again, the annual monthly retainer deal that I was talking about, can you just back out 6 months in and say, see you later, Bob, I'm out? And if so, how do you do it? Is there a 30-day notice provision, a 60-day notice provision, or whatever? And then on the flip side of that, can your client also do the same thing? So effectively, the question is, can they fire you 6 months in? And if so, how does it work? Do they give you 2 months notice or 2 weeks notice? Whatever it is, it's totally up to you to define those terms. If you're an employee, most employees are at will, which means that either side can quit or get fired at any time for any reason, well, as long as it's not illegal, discriminatory, age or gender, whatever. Whereas a contractor relationship, that's not how it works. It's whatever you put in your contract. So the way I like to do this is usually to say that the client can fire you with 30 days prior notice. And then if you can get if you can get this in there, you can also quit with 30 days notice. To me, that seems to be the most fair. However, 30 days might not always be right. Maybe you want 15 days, or maybe if it's a long-term contract, 60 days is more appropriate. But then you have to think about, what payments are owed after that. And so if you're going to have a 1-year contract with monthly payments, I like to say that there's a liquidated damages provision that says if the client cancels early, they have to pay you what's called liquidated damages. And that's just a fancy way of saying a cancellation fee. And normally it's some percentage of whatever they owe you moving forward. And so, if they cancel 6 months in, they might owe you 50% of the remaining monthly payments. Or at a minimum, go back to requiring 30 days notice, just to make sure you don't get hung out with no income coming in for a month, because it's going to take you a while to replace that client. And then also make it clear that if they are paying you for reimbursable expenses, that they still have to reimburse you for anything you've already paid for, plus anything that maybe you haven't paid for but you might have to pay for later. You might sign up for a 12-month hosting plan and pay $20 a month. Well, if they cancel in month 6, you're still on the hook to pay the last 6 months. So you want to make sure that they still have to pay you for whatever those expenses are. Or in that case, you might transfer hosting to them and they take it over. But the key is to make sure that you're not left paying that out of your own pocket. And then the last thing for termination is to think about what's called a breach and cure provision. What this says is that if either party breaches the agreement, so your client fails to pay you, or you're just not delivering the assets to your client, or whatever it might be, in that scenario, the other party, the non-breaching party, can deliver notice to the party that is breaching and say, hey, you're in breach. You haven't given me the assets you promised me. If you don't give them to me within 15 days, I'm going to terminate this contract. That's really useful if you have a long-term contract with no voluntary termination rights. If you do a 1-year contract, but nobody can terminate early, you at least want to have breach and cure in there. So if the other party is just kind of walking away, that you have the ability to terminate the contract. If you have a 2-week voluntary termination right, then there's not much reason to give a 15-day breach cure provision also, because you could just terminate with 2 weeks notice, right? So in that case, you might even make a faster breach cure provision that says you only have 5 days to fix whatever the breach is. Point is, make it clear in the contract that you can terminate under those scenarios. And those are the 3 that I see the most. The last comment I'll say here is, if you also have subcontractors working for you, make sure you think through how you terminate their contract. So if you do a 1-year contract with a client and you have a subcontractor that's going to come on board to help you during that whole window, it would be really bad if your client could terminate 6 months in, but you couldn't terminate on your subcontractor, because then you're on the hook to pay your subcontractor for a full year. Meanwhile, your client's only paying you for half of that. So just make sure that your subcontractor agreements mirror to some degree your client agreement termination provisions. Okay, moving on to what I'd call miscellaneous terms. I'm not going to go through all of these because it's just a bunch of stuff. I have a blog post, plus it's in a few of my ebooks, kind of talks through all of these in greater depth at both venturelegalkc.com and contractcanvas.com. But I am going to talk through just 4 of them real quick, because I think they're the most important miscellaneous provisions. The first one I'll talk through is assignment. So normally a contract says that neither party can assign their obligations to any third party. What that looks like for you is you're not allowed to assign your obligations to develop a logo to somebody else. And that makes sense. If your client hires you to make a logo, they don't want you to, farm it out on Fiverr to somebody living overseas and for you to pay $5 for it. Meanwhile, they're paying you $1,000 and they get some crappy logo. But what you might want to have there, though, is some provision that makes it clear that you can use subcontractors. Because, if you're a logo designer, you might not need a subcontractor. If you're building out a whole website or doing a whole marketing strategy, you might need a subcontractor, and this provision might actually prohibit it. So if it does, you'll want to make sure you add in a sentence that says something like, Chris can use subcontractors, provided Chris remains liable for all of his obligations in this agreement. Sometimes the client will say, well, I want to have a right over who you use. And so in that case, it might say, Chris can use subcontractors, but only if they're pre-approved by the client, kind of like the reimbursable expense item we talked about earlier. I think his name was John, maybe. No, we don't have a John. Somebody on the phone asked about, doing it via email. And so if you need to get that approval via email, make sure you put that in there to make it clear that the email permission is sufficient. Then we've got governing law and jurisdiction and venue, and these are extremely similar. Governing law says which state law will apply to a dispute if a dispute arises, whereas jurisdiction and venue says where you have to actually bring the lawsuit. And this is usually not a huge issue for freelancers, but it can be. So if you're hiring or I'm sorry, if your client is hiring you and say they're in Kansas City, Missouri, and you work in Kansas City, Missouri, so the governing law is Missouri, jurisdiction is Jackson County, that's easy, no problem. But let's say that your client is based in California and they give you a contract to review. And so the contract says governing law is California, and if you want to sue them, you have to go to California to do that. You probably don't want to agree to that. Agreeing to California law is not in and of itself a bad thing, but agreeing to use California courts can be a disaster, because then you literally have to go to California to file the lawsuit. So you might strike the second sentence that talks about where you sue, but keep the first sentence. And then the last thing, attorney's fees. This is a great provision for freelancers to add in there. You can either add in a broad attorney fee provision that says if either party sues the other and they win, that the losing party pays the winning party's attorney's fees, or you can limit it further and just say if you have to sue to collect payment, which is really the only reason you'd likely sue your client anyway, that you can get attorney's fees. And at a minimum, I would do that second option, so that if your client doesn't pay you, not only can you say I'm going to sue you to get paid, but you can say I'm going to sue you, and when I win, you have to pay my attorney's fees. That makes it a lot easier to hire a lawyer if that situation arises. We're going to jump into how to review a contract, as well as how to negotiate a contract briefly, and then I'll also have some time at the end for Q&A if anybody wants to chat. Okay, so in terms of reviewing a contract, I think that's the next slide. So I have on contractcanvas.com this review checklist, and there's 25 different things in there. And so that's at contractcanvas.com. What I'm going to do though here though is just kind of give you a high level view of how you would want to go through this process. Okay, so I said 2 considerations. That's obviously not right. Should be 5. Anyway, that's copy and paste error on my part. So anyway, the 5 different things that you want to talk through. So first of all is, what are your expectations? You know, if you're doing a logo design project, you know, your expectations might be that you're going to do 3 rounds of designs and you're going to get paid $5,000 and it's a 2-month contract. Right? Make sure you understand what it is that you want out of the contract before you start diving in. Next thing is that you're going to review these sections first, in my opinion. So services and payment, which kind of go together, to make sure that, you know, 3 rounds of edits and $5,000 is correctly represented in the contract. Second is intellectual property, to make sure you understand who owns, you know, everything you're making. And then last, oh, that's another error on my part, termination rights. So, you know, how do you cancel the contract early, and so on. Those 3 are usually the first 3 things that I look at when I dive into a contract. You could start at the top of the contract and just start reading all the way down, but I found that that's not really the best way to do it. It's best to actually look at these sections kind of in this order, and then you go back to the top and then you start reading the rest. So that's bullet point 3 there. You really have to read the whole thing. I know a lot of people hate doing that, but there could be something strange hidden in there somewhere that, you know, shouldn't be in that section, but it is, and it's binding, and you might be agreeing to something you didn't like. After you've done all that, you should consider 2 things. One, is anything missing? And if it is, try to add it in if you can. So this could be things like reimbursable expenses. You know, if your client sends you an agreement to review, it's very likely that it doesn't talk about reimbursable expenses. And if that's the case, you should add that in there. And if it's not a Word document, then send them an email and say, hey, can you add this sentence into section 3 or whatever? And then also think about, does anything need to be changed? So, you know, this can be difficult. It's hard sometimes to negotiate a contract depending on, you know, who you are and who you're working with. But if something is wrong, you just need to ask about it, because you don't want to sign it knowing it's wrong, because then you end up getting yourself into trouble later. And so that's actually my next point when it comes to negotiating a contract. Always ask questions. You know, you might think it's wrong, and then when you ask a question, you realize, oh, that's what you're talking about, and you just kind of misread it. Or maybe there's a provision in there that just seems really unreasonable to you, but when you ask about it, you understand why they're asking for it. Maybe they've been burned by a freelancer in the past. Point is, have a dialogue. Contracts contain mistakes. Sometimes people don't realize what's in them sometimes, and asking questions and just being honest and transparent is usually the best way to address that. Don't just jump to the conclusion that they're trying to screw you over, because more likely it's just miswritten or something. Understanding your bargaining power. If you're signing a contract with Google, you're probably not going to get to change anything in the contract, because they can hire kind of any contractor they want. If you're signing something with my law firm, for example, Venture Legal, you probably have a lot more wiggle room. You know, I'm a solo business. I'm a freelancer myself. So you've got a lot more bargaining power when you're working with somebody smaller like me than when you're working with a big company. Add and remove things as needed. That gets back to my last point on that last slide. Don't be afraid to add things if they need to be added. Use track changes whenever possible. So if you're working in Microsoft Word, just go up to the top, click review, and turn on track changes. Do not use formatting to do track changes. I got a 45-page contract back one time from somebody, and they had literally formatted track changes. So they used red font and strike through text and blue font for inserting text, which is what track changes does in Word, but they literally went through and formatted the whole thing, and it was a complete disaster. So anyway, turn on track changes and just use it because it makes your life easier. And then the last thing I'll say is to try to keep their language. So, you know, if their contract says something like, contractor will ensure that the website is live 100% of the time. Well, you can't really make that promise. So you might just think, well, I'll just delete that. But it's often easier to just revise their language a little bit because it's easier for them to accept a revision more so than a complete deletion of a provision. So what you might change is, instead of saying contractor will keep the website live 100% of the time, first thing is change 100% to like 99%. Because, you know, websites go down for a minute or two here or there. The other thing you might change is, instead of it saying shall ensure, maybe it just says contractor will use its reasonable efforts to ensure the website is up 99% of the time. And just doing those two little changes are usually easy to get approved, and they reduce your liability and risk quite a bit. So again, at contractcanvas.com, you can check out this 25-point contract review checklist. There's actually 3 or 4 other resources on that website. There's a free client agreement for very small projects. There's an ebook about client agreements and a few other things. And then also at venturelegalkc.com, I've got 4 different ebooks, one specifically on freelancing, another on small businesses, one on contract law, and one on intellectual property. So if you want to check any of those resources out, you can. And that's all I've got, but I know that there's one other question in here, and I know we've got to wrap up in about 10 minutes. So, well, real quick, here's my 3 emails. Chris at both my websites. You can find me on Twitter, CSP Council. Little selfish plug there. I just crossed 1,300 followers, and I hate the number 13. So if anybody can help me get to 14 quickly, please do so. But that's probably going to take me a few months. So the next few months, I'm going to have bad luck. But aren't we all, I guess, right now? Okay, and then the last thing, Contract Canvas. If anybody wants to use the referral code FX of KC when you're signing up, you can get a free month of Contract Canvas by using that referral code. Okay, so back to the questions. Stacy Webb asked, if governing law is California or any other state, can you go to court in Missouri? How do you avoid out-of-state court? Oh, that's a great question. So any court in the country can apply any other state's laws. So a Missouri court can apply California law to a dispute. And that happens pretty regularly, actually, because most contracts state what state law applies. So a lot of large Fortune 500 contracts, regardless where the business is, will say Delaware law applies. And that sounds random, but Delaware law is business friendly. Their law is extremely well developed in the business world. And that's what law students learn. So in law school, you typically learn the law of the state that you're going to school in. And in my case, we learned both Kansas and Missouri, but then you also learn Delaware. It's kind of like the fallback, if you will. So anyway, any state in the country can enforce Delaware law. Or I shouldn't say it like that. I should say that they can use Delaware law to resolve a dispute. But that gets back to when I said governing law and jurisdiction are 2 different things. So governing law is which state law will apply to the dispute. Jurisdiction, or sometimes called venue, is where you have to sue, right? So to avoid getting sued out of state, you need to get rid of that jurisdiction and venue sentence.